right, good afternoon to you, and welcome to another edition of Wheel of Justice, the program designed to break down the administration of criminal justice law 2017 in ways that we can all understand. I'm talking about both the legal professionals and those who have no idea of the legal system at all. Now, my name is Ifeanyi Awa, and on Tuesdays from 3:30 p.m. this program comes your way on this station, Flow 94.9 FM. It is brought to you by the Acjl State Administration of Criminal Justice Monitoring Committee, Prisoners Rehabilitation and Welfare Action Power, with the support of Open Society Initiative for West Africa (OSIWA) and the Acjl State Justice Reform Team. This week, we'll be talking about alteration and amendment of a charge under Part 22. That's where you can find it, of the Acjl 2017. And my guest today is Abai Iro Ubuabi, am I correct?
Yes.
Esquire. Hey, he's a legal advisor. That's the MBA, Nigerian Bar Association, Ohafia. Also, Assistant Chief State Counsel. He is a PhD student of international and it's cooperative law in UNN. Welcome to our studios.
Thank you, my brother.
All right. Now, the issue of charge. We've talked about charge before on the program, and it's something we are familiar with. But when we talk about the alteration and amendment of a charge, what exactly are we hitting at?
When we talk of alteration and amendment of a charge, that presupposes there is an earlier existing charge. And the term alteration and amendment refers to the same thing. Either you alter the old one by amending it or by substituting. So alteration, amendment, and substitutions are ways by which an existing charge are either corrected or whatever that is not good is removed. That is what we refer to alteration, amendment, or substitution.
What exactly can cause a charge to be amended?
When a charge is filed, just as every human frailty, it may be found out that there are things that are extraneous to it or that are not supposed to be contained, or the need for additional counts. So you do it by way of amendment of the existing charge.
Now, on Part 22 of the Acjl, it gives details on, deals with the issues of the amendment of charge. So what exactly has been outlined when it comes to this part of the law?
Just as I said earlier before the need to amend a charge arises, that means there is an old charge. And when an old charge has been filed, the court becomes seized of that charge. So whatever you do must be by the leave of court. Having filed an existing charge already, that is to say, the prosecution, either by way of the Office of the Attorney General or other prosecuting agency, must seek permission from the court. That is why you amend either by substitution or by alteration if it is materially different to be affected. So the proper thing to do is to substitute a new charge, and which dates back to the time of the old charge. Okay. Instead of starting all over a new scenario again, you substitute the existing charge. That is to say, the new charge dates back to the old charge. But if it is a minor error, that's where you can do by alteration. No need of substituting the old charge. You do one or two alterations, and then it reflects the intent of the prosecution.
In order to make this easier for our listener to properly understand this, let's use an example where maybe an accident happens. Someone drives a car and hits someone who later on dies, and you might have the charge of murder. Now, can we use such scenario to explain this? What if there's an amendment of charge? What might turn up in that case?
One, following your question, in the course of the accident, murder may not be imminent. So you may charge reckless driving at that stage. If in the course of that trial, it gets to the murder stage, it will be inappropriate for you to be running two charges on the same defendant. Instead, the proper thing is to incorporate the new offense which has been established by this act of murder, so that two of them run side by side.
Okay, I'm sorry. I'm trying to make this easier for the listener to pretty much understand this. You're saying, still using the example given, we have you talked about the issue of reckless driving, and there's murder also involved in this now. And it said if this maybe later on during the case, after it has been amended to reckless driving, and during the case discovered that there might be a situation, a case of murder, what exactly happens now?
What I said, one, in most cases, the first prosecuting authority may not be the office of the Attorney General.
Okay.
It may be other prosecuting agencies like the police we have. When the case file is vetted, other facts may emerge, which either will necessitate a reduction in account or an addition in account. So what the new prosecuting authority now does is to see how you reflect in the old charge, either by way of dropping some or addition. That is why we say it can be by alteration, it can be by substitution. And substitution is resorted to when the need for amendment is so material that it will be inelegant for you to start altering this. You do a substitution. But the good thing is that whether by substitution or by alteration, it relates back to the old charge.
Okay. Now, subsection 2 of this part 22 does state that an alteration or amendment of a new charge shall be read and explained to the defendant, and his plea to the amended or new charges shall be taken. So that means it must necessarily be explained so he understands what these new charges are.
The fact is that the Constitution writes to a defendant that he must be presented with any charge of which he is faced to answer. That's a constitutional right. When an old charge is read and you come up with an amendment, you take back that step, because the one that you explained before, you have amended it. You need to re-explain the new charge in line with the constitutional requirement that a defendant must be presented with whatever allegation that is against him. So when a charge is amended, by that constitutional provision, you are to explain it back, and he takes a fresh plea, because the new charge now, he may decide to change a plea.
Okay.
So that is why you must present it back to him. This is what is now before you, not what was read before, then what is your plea.
I want to talk about trying to change a plea. Meaning he might, maybe the first one he was going for guilty, and then the second charge
he might say not
guilty. Okay. Now going further, because I'm going to pick out different parts of this section. It's the part 3 actually says, where the defendant is arraigned for trial on an imperfect or erroneous charge, the court may permit or direct the framing of a new charge or amendment to, or the alteration of the original charge, which is exactly what you've been explaining right here. It means the changes that will come to it when it is discovered that there's been some mistakes in it. Now, does that a part of this law that gives the judge the right to change it?
Under the Acjl, the judge or the magistrate cannot change. The same may permit.
Okay.
The application for amendment must come from the prosecution. But because it is the court that is seized of that trial, that application must be made before it. So that is why the application will not be made by court, but the permission to amend is gotten from the court. So whether it's an imperfect, it is the prosecution that must seek for the amendment.
Okay, what if a situation where the prosecution brings up a case with a particular charge, and when it is read before the court, the judge feels, you know what, I don't think this should really be the charge here. Is this possible?
Going by Acjl 2017 and the adversarial system we run, the judge's duty is of an impartial umpire.
Okay. All right. Now, 4 says, where the defendant is committed for trial without a charge or with an imperfect or erroneous charge, the court may frame a charge or add or alter the charge as the case may be, having regard to the provisions of the law. So, what exactly does this mean?
What it means, if they say the court may, but just as I've said, that may of the court is to permit the prosecution under our Acjl. There is no provision for the court on its own somoto to amend it. It must come from the prosecution. It is a provision that happens in the north, that where the magistrate actually frames the charge. But in this our system, that is a mix-up.
Okay.
That court should be read as permitting the prosecution to amend. The court cannot on its own amend this charge under this our Acjl.
Okay.
It is the permission given to the prosecution to amend.
All right. Now, if you're just tuning in, I'm speaking with Acjl Ubwabia, who is Esquire, who is the legal advisor to the Nigerian Bar Association, or HAFIA. He is the Assistant Chief State Counsel and also a PhD student of International and Cooperative Law, University of Nigeria in Nsukka. And we've been looking at alteration and amendment of a charge under the Part 22 of the Acjl 2017. We're going to go on a very short break. When we'll come back, we'll continue our conversation on this as he continues to dissect this particular topic. Stay tuned. This is still Wheel of Justice. Welcome back. This is still Wheel of Justice, and my name is Ifeanyi Awa. Don't forget this program comes away 3:30 right here, Flow 94.9 FM, the Flow of God's own state, and it is brought to you by the Abia State Administration of Criminal Justice Monitoring Committee, Prisoners Rehabilitation and Welfare Action Power, with the support of Open Society Initiative for West Africa (OSIWA) and the Abia State Justice Reform Team. My guest this afternoon is Acjl Ubwabia, Esquire, who is a legal advisor to Nigerian Bar Association, or HAFIA, Assistant Chief State Counsel, and PhD student of International Cooperative Law, University of Nigeria in Nsukka. And we'll be looking at the alteration and amendment of a charge under Part 22 of the Acjl 2017. He's been doing a very good job in terms of dissecting this law, part of the law. We'll continue our conversation on this. Now, we've talked about where the court may frame the charges, new charges. Now, what happens next when a charge is framed? What happens with the plea?
When a charge is amended, altered, or subverted, the defendant takes a fresh plea.
And is this true like a new case?
It's not a new case because by the law it dates back to the old. But having altered it, he takes a plea to know either what he took, the plea he took then is either he has changed his mind. So he takes a plea.
All right. Now, it says where a charge is so amended, a note of order of amendment shall be endorsed on the charge, and the charge shall be treated for the purpose of all proceedings in connection therewith as having been filled in amended form. Do you care to explain this part for those who might not understand it?
What that provision is saying that when there is amendment to the charge, the court must make an endorsement as to that amendment. Assuming the case was filed last year and there is an amendment this year, there must be an endorsement as to so and so charge dated amended today, so that if amendment is done in 2018 of a case that started 2016, there must be an indication in order to keep that record, even though the charge relates back to the old charge, but that endorsement of the steps it has taken to that stage must be made by the court.
Okay.
In order not to lose track.
Okay. Now, in terms of the what you call it, in terms of the witnesses to the case, what happens in this scenario? Maybe a witness has been there for the first charge, and there's an amendment. What happens to that witness?
One, when a charge is amended, the next step is, does this amendment materially affect the evidence that have been led? Because an amendment may be so material that there is need to recall those witnesses. They may have given evidence not in line with what has been amended. Therefore, there is need to record them in order to lead evidence. But there may be amendments that are so immaterial that what the witness has said stands even in the amended charge. There may be no need for the prosecution to bring them back, but the defendant has an unfettered right if he seeks for their recall.
Okay. Now, I omitted this part earlier, which I'm going to head back to. We've talked about what the court can do, what the prosecutor can do, and we're talking about the defender, just more like an institution will put it, being inactive in the situation. Now, can the counsel to the defendant move for a motion for an amendment of the charge?
The defendant's right to defend himself does not extend to dictating what he should be charged with.
Okay.
It is a state that checks out an offense that have been made and charge accordingly. So it is the unfettered right of the state which is represented by the prosecution. You can't tell the state the offense you think you have committed. It is the state that determines what offense. But in that regard, that is why it must be read out to you, in order for you to know what the state thinks you have committed, and then enable you with the facilities. Whatever proof of evidence that the state has, you will be enabled in order to prepare for your defense. So it is not head off for somebody to choose what he will be tried on.
Okay. Now, still continuing on this, moving forward, says an error in stating the offense of the particulars required to be stated in a charge, or an omission to state the offense of those particulars, or any duplicity, misjoinder, non-joinder of the particulars of the offense shall not be regarded at any stage of the case as material unless the defendant was in fact misled by the error or omission. I might think some confusion there. Please do explain it.
It's self-explanatory. What that provision is saying, when a charge is framed, no omission or misrepresentation that shall be regarded as material, except if it actually in fact misled the defendant. What we mean, somebody is charged for committing a crime in Omahia, in Abia State, and he is aware that it happens in Afara. Afara is in Omahia. If it is such that it does not mislead you, the fact that it wasn't stated it was in Bank Road, no objection shall be taken on that, except if by the face of it, it is shown to have misled you. So it is subjective. It is for the court to see if actually it has misled, because the constitutional right of being faced with what you are to answer, if the charge does not mislead you, because there are cases whereby at the end of the trial some frivolous issues are brought up, whereas the defendant has faced the case in its merit, but possibly upon conviction start bringing up there was no mention as to the time of the day, 2 p.m. but you defended it, there was a date, possibly there was no 2 p.m. So you bring up an accusation, it did not state the time of the day. So if those things are there but it does not mislead the defendant, it shall be counted as immaterial.
Okay, so moving on, you talked about objections, and there's a part of this that says objections shall not be taken or entertained during proceeding or trial on the ground of an imperfect or erroneous charge.
Yes, prior to the enactment of this Acjl, the law was that objections shall be taken promptly. Every failure to take prompt objection after plea has been taken will be deemed as a waiver. It cannot be entertained. Then, because of some trials of some politically exposed persons and economic crimes, you see that they became litany of objections in order to frustrate trial, that it may hold up a main trial for years with successive interlocutory applications, even on appeal. So part of the novelties of this new law say that no objection shall be entertained on the basis of such. Instead, that objection will be taken and judgment delivered together alongside the main trial.
Okay,
that is to expedite criminal trials,
which is actually part of the aim of the Acjl, to make sure that
speedier dispensation of
justice. Yeah. Now we're almost done with this part of the Acjl. But let me just two more. It says, where an appellate court is of the opinion that a defendant convicted of an offense was misled in his defense by the absence of a charge or by an error in the charge which was occasioned a miscarriage of justice, he may direct that the trial be recommenced on another charge.
Yes, that is part of the supervisory functions of the appellate court.
When we say appellate court, we mean higher court?
Appellate court means court higher than the one that tried. The high court is an appellate court to a magistrate court. And the court of appeal is an appellate court to the high court, while the Supreme Court is an appellate court to the court of appeal. So the hierarchy, of course, everyone above you is an appellate court. So what we are saying now, if the trial court on its own, upon that application for objection on the ground that the defendant was misled, and the court rules out that the defendant was not misled, he has a right of an appeal, which he will present, and the court of appeal or the appellate court now, based on the record of proceedings before it, will consider it on an appellate ground. If there is findings that the defendant was misled, it is proper that will be the proper order to make that it should be tried on another count. That is order for retrial.
Now, the last part says, where the appellate court is of the opinion that the facts of the case are such that no valid charge could have been preferred against the defendant in respect of the facts proved, it shall quash the conviction.
Yes, when after the evaluation, there exists a ground to believe that there is a case made out, the court, but the procedure wasn't properly for the court will order for a trial.
Okay.
We saw it in the case of the ex-governor of Abia State, where the Supreme Court ordered for a trial. That means outside the procedure, there are grounds to proceed. But when the court is of the opinion, given the facts as established, there is no ground to proceed, the court will order a discharge, because it will be a waste of judicial time.
All right. Thank you very much. I think that's the last part. We can take us some time. But I think the take home today is that charges can be amended
at any time before judgment.
Yes, before judgment. And there is a basis for that in the Acjl. So yes, it shouldn't be news to anybody now. And also we've explained other things that comes when there's the alteration and amendment of a charge. A fresh plea is taken. Means that if there's an amendment of a charge, you are given the opportunity to either to plead guilty or not guilty again. If you've pleaded maybe guilty or not guilty the first time, you are therefore required to again plead guilty or not guilty to the fresh charge put in place. Thank you very much. Abai Iro Ubuabia Esquire, legal advisor, Nigerian Bar Association on Hafia, assistant chief state counsel, PhD student of international and cooperative law, University of Nigeria and Nsukka. It's been nice having you right here and doing justice to this topic.
Thank you.
All right. Anyways, don't forget again, we're back, God willing, 3:30 next week Tuesday, and this is Will of Justice brought to you by the Abia State Administration of Criminal Justice Monitoring Committee, Prisoners Rehabilitation and Welfare Action Power, with the support of Open Society Initiative for West Africa (OSIWA) and the Abia State Justice Reform Team. My name remains Ifeanyi Awa. Do continue to stay tuned to the session. There's more to come. Have a lovely day ahead.